Looks like we're streaming live, Judge Fleener.
Okay, I will call this meeting to order. I want to thank everyone for being patient with us this morning. Our first item of business this morning is for roll call. We have Judge Coleman,
Here.
Judge Vincent. I think he's here. Kevin Phelps.
Here.
Melissa Cardwell,
Here.
Colton Gibbons.
Here.
Okay. First item of business this morning is approval of our minutes from 4/19/2023. If you all had those, if there's no additions or corrections to the minutes, I will entertain a motion to accept them as presented.
I move we accept them as presented.
Have a motion by Kevin,
Second.
second by Melissa. Is there any discussion? Not hearing any. All in favor of the motion, let it know by saying aye. All opposed? Motion carries. Our next item is land acquisition. Mark?
Yep. I mean, basically, Judge Fleener and then have been checking on the, if there was going to be any additional endorsements to the title insurance. And I believe the conclusion we came to a couple of days ago that just the regular title insurance as is sufficient.
Yeah. And what we based that off of was because of the architects and the construction workers. They will also have insurance and liability insurance on for the project going forward. Okay. So with that, we need a motion for us to purchase the title insurance and to go ahead and purchase the property.
I move that we purchase the current title insurance and go ahead and go forward with purchasing the property.
Okay, I have a motion to purchase title insurance and the property. Do I hear a second?
Second.
Second by Colton. Is there any discussion on this? And the one thing that led us to do this decision just for the title insurance instead of the whole project insurance was that the other projects that AOC is done in the past have not had the whole property insurance on them either. It's just been with title insurance.
Also want to, can I add one thing real quick, Judge Fleener?
Yes,
and
yes.
also too, I'm assuming we're going to have to get the closing statements. We won't have the exact amount until we get the closing statement. Could possibly Colton or Michelle review the closing statement to make sure everything's in order on our end. And then I will work with US Bank to get the funds transferred into the closing attorney's escrow account.
Yeah, Mark, I'd be happy to look over that if you just want to email that to me.
Okay.
Thank you, Michelle. All right, is there any more discussion? If not, all in favor of the motion, raise your hand, please. We'll take a hand vote on this. So I have Colton.
I'll abstain on that.
I'm not going to say, Judge, you're abstaining from the vote. Kevin and Melissa. Okay. All opposed, the same. Motion carries. Okay, is there any other business to bring before the board this morning?
What about the closing date? Are
Mark,
we able to set that?
setting a closing date?
I assume we'll get with the closing attorney and see when they can close it. And then depending on how long it takes me to get the funds transferred, we'll probably set it based on how long. It shouldn't take it but a couple of days to get the funds transferred once we know the exact amount.
Okay.
And I can reach out to the law firm and see if I can get a date if y'all would like me to do that.
Okay.
Yeah, that would be great, Michelle.
Okay, I'll reach out to him today.
So just real quick, Michelle, while I got you on here. So basically, we'll prepare what's called a disbursement request, and we'll end up getting, basically, that'll have the amount of how much needs to go in the closing attorney's escrow account. There's a small approval process that we have set up through basically Lynn Imaging that tracks all these invoices and whatnot. We'll get that taken care of, and that'll end up going on to the bank trustee. And we'll probably get whatever, wiring information that the closing attorney will provide so we can get the funds transferred. And then that's how just so you know, that's how that'll get handled. It'll take us a few days to get that resolved.
Okay, all right, thank you.
At this time, is there anything else? If not, we need to set a meeting date for next month. Is Tuesday still okay?
Hold on a second there, Judge Fleener.
Okay.
I'm sorry, I thought you meant anything else from the board. I did have something.
Okay, Jeff, go ahead.
First of all, once the property is finalized, one of the things we'll need to do, and this shouldn't, I don't even know if he'll charge for it, but one thing we'll need to do is on the previous discussions regarding the easement along Ohio Street, because right now the easement is recorded on the property as, the width it is today. And so we'll need to get that adjusted on the survey to reflect the new easement. And from our previous discussion, what I understood that we were going to do is we're going to assume there's a sidewalk going down the street there on the backside, and then we would place the easement on the backside of that. So there would still be a small, like 5-foot easement or so off the street, but otherwise our property line would go right up to the sidewalk. And if my understanding of that is correct, and I won't do it yet because we'll make sure that the property is working out and all that. But what I'd like to do as soon as we've got that nailed and closed and all, is if it's okay, reach out to the surveyor and get that updated. Does that make sense?
Yes, it does, Jeff. The only issue that we have with that right now at the moment is the state is going to turn that street over to the city.
Okay.
So I don't know that we can get an easement on that from the state until
that happens.
Until that happens.
Yeah, and I don't really know what that process is or how long that takes. I haven't a clue, but
yeah.
Okay.
Judge Fleener, have you heard anything on the status of that?
No.
Okay.
Yeah, because
just that was the understanding that I got from the mayor was that they would the state would deed that over to them. And now how long that takes for them to do that, I have no idea, Mark.
Okay.
I think the important thing is just to find out if they've actually said, let's get going. I know they've talked about it, but has anyone said, yes, let's go ahead and start that bureaucracy or whatever that is, so that it's in the process. That has a significant impact on the site layout is, knowing that. I don't think we really want to proceed until we know we've got that nailed, but doesn't sound like it's a problem philosophically. It's more that we just need to know that it's legal. So
right. What I can do, I'll reach out to Joe Plunk, our district 4 supervisor for our road supervisor for our area, and see what he says, how long the process.
Okay.
Tim, who are we using as the surveyor?
Cody Henderson.
Cody, okay.
Well, no.
No.
This is the surveyor for
That's right.
for the project
Right.
that we would be talking to. So that's QK4. So again, it's just a matter of asking them to do it, but I don't want to make an official change until we, obviously, until you've got the city's got title to the street. That would be premature, but we just want to do that as soon as possible because that will affect the layout, not so much of the building, but it's going to affect the site layout considerably. So. Okay, well, just, once you find out anything, if you could let us know, how that looks, if it's going to be, if it's simple or whether it takes 6 months or whatever. I really don't know.
Yeah.
Hopefully not the latter.
Hopefully.
Yeah. And I did have one other thing, and I don't know, we don't have to talk about this today. We can or we cannot. I know there's some people missing. So Melissa's not down here yet, right?
Yeah, Melissa's here. She's here with the man.
Oh, okay. Well, what I brought up the last meeting that needs to be discussed at some point, once we're authorized to begin, it all starts with the program that you all have had for a while, and some potential adjustments to that program based on the experience we had at Crittenden County, which was otherwise the identical program, but for the name at the top. And there were some significant changes made there for good reason to that program, which resulted in the building increase in size. So we would need to know that before we actually got into the discussion on the design. So I have what we put together for Crittenden to kind of explain that. It's not a simple explanation. It's a rather complicated, but at some point we have to have it. And I just don't know if that's something you all want to go ahead and do that, or whether you'd rather wait to the next meeting. I won't be doing anything with it right today other than explaining it until we move forward with the property. But at some point we do need to have that talk. So you just tell me when you'd like to do it.
Hey, Jeff, we do have Judge McCown, the family court judge, on today.
Okay.
Judge
Can we go
McCown,
ahead and do that?
yeah, let me see. Are you going to be in your office, or are you out of the office, or because Jeff can basically share his screen? I didn't know if you could be able to see this or not.
You're talking to me, Judge McCown.
Yes.
I'm pulling in to the Butler County Courthouse now and can do that. I'm on my phone now and can probably even see whatever that is if you give me just a second.
Yeah.
But
That's
however,
fine.
I mean, I don't know what it is you want to show me, but whatever works best for you all is fine with me.
Yeah, well, it's not a drawing. It's really
Okay.
just it's the program and what we did to revise it. It's a bunch of words. So
Oh, okay.
it's not hard to see it, but it does help to be able to point.
Okay.
So maybe you can just let us know when you're settled enough to where.
I'm settled enough.
Okay, cool. So Mark, can I just kind of explain generally let me just try to go with the general explanation first, and then we can talk about the specifics. So like I said, Crittenden, Butler, identical to the last, number, no difference as they began. So there was a rather lengthy process on Crittenden to discuss some changes that the PDB there felt needed to be made. And ultimately, the AOC approved those. And so, Crittenden's about ready to go out to bid now. So we've kind of been down that path with them already. And once it was decided early on that the program would have some adjustments, that stuck with it through the rest of the project. And, there were no further changes. So it basically involves, I would say, two major items. One is that your program includes family court spaces that are identified, a family court judge, for example. And even though there is no specific family court room, the way the AOC does it, on a building of this size, they have a jury trial courtroom and they have a non-jury trial courtroom. So two courtrooms, one simply has a jury box, one does not. The non-jury trial courtroom is generally smaller, and that would be the one typically used for family court, although, they're both available. There weren't any adjustments recommended for the family courtroom or the non-jury trial courtroom, one and the same. However, what was absent from the program are spaces that are generally associated with family court. And they just weren't there. For example, a space for a family court administrator, and the areas related to the child waiting, an associated toilet and an observation room for that. Every family court that we have done, without exception, has always had those spaces. And that was missing from this program. So on Crittenden County, those spaces were added in to the program. So that's one thing. Secondly, one of the things we noted was that when the program was prepared, and given to us by the AOC, the building has usable spaces, which are basically the net areas, the actual, where you can walk in a room and stand, that's the net space, as opposed to the gross area, which includes the walls. And also the way the AOC has done it, the gross area includes circulation spaces, corridors, stairs, elevators, all of those things that are necessary, but they're not a program space as far as a usable space. So what we found on these programs is that the percentage of area allowed in the program for those was insufficient. And I'll give you an example. We just recently did, and it's under construction now, the Oldham County Judicial Center, and there was a 35% grossing factor, which accounted for the walls and the corridors and stairs and all of that included in there. However, on Crittenden and Butler, it was only about 23%, which is way low. You simply can't, even with the most efficient layout possible, there's just not enough space in the building to fit all of those required gross areas in, along with the program area. So for example, on Bath County, which is a building of very similar size, it was like building a watch. It was very, very efficient as far as the layout, not any wasted spaces. None of the program spaces were inflated in size, et cetera. But that building still ended up being about 1,000 square feet greater, just because we had to fit all of those things in. So we brought that up on Crittenden, that was the case here. That 23% grossing factor was way low. Normally, the way these buildings lay out, if you have a 35% factor on a very large building, as a building gets smaller, it doesn't get better when it comes to the grossing. If anything, it would have to be at least the same, sometimes even more. So going down to 23 from 35 is going the wrong direction. So I know this all may sound like a whole lot hearing it for the first time, but there was a considerable amount of discussion on this on Crittenden, and the AOC authorized, the building to accommodate that increased gross area. So that was the second thing. We had the family court spaces that were added. We had some additional gross areas that were added. And then something else that came up unrelated to both of those things, in the jury trial courtroom, they felt strongly that there was insufficient spectator area. And so the spectator area was increased. The litigation space, same as we were planning on, it basically just added more rows of seating in there. And so that was an additional increase in the size of the building. So all that having been said, that was approved by the AOC. That's the way the plan was laid out, and it stayed that way right up until what we have today, are the bid documents ready to go out. So and I'm not saying that you all have to decide this today, but those are the basic issues, and I can show you graphically here on my screen, if you'll give me a moment, just the side-by-side comparison. So I'll share my screen here. Oh, okay. So, so this little document that you're seeing here is, get this out of the way, is the document that we use and have to submit to the AOC. You know, once you get to the end of phase A, one of the items that has to be shown to the CFSC committee is the original program compared to what they're actually seeing in the schematic drawing layout. And this is just in a tabular format, this Excel file that you see here. Obviously, there will be floor plans that go with this, but they want to see a side-by-side square footage comparison. So the first thing you'll see here is, and I'll just zoom this in a little bit more, is in the jury trial courtroom, that increase requested by the PDB for the spectator area. It was 850 square feet. It went up to 1,200. So that's highlighted in purple because it's not a new space. It was simply an increase in space. And then what you see in green here are spaces that were added that I described for the family court administrator, and then the child waiting toilet observation areas. Those are spaces that did not exist and are now inserted in the program. And then as we get down here, I've added things that we've seen in previous programs.
Can I ask a question?
Of course.
And so the document you're showing, is this the Crittenden County or is this what
Yes,
the
this
Butler
is Crittenden
Okay.
County.
Okay,
But
I was just
again,
making sure. So these
yes.
adjustments haven't necessarily been made to the program in Butler County. I was just making sure I was understanding what we were looking at. Go ahead.
You got it. Yeah. So this column right here is exactly what came off the page from the AOC. And the next column over is what was changed. That's where you see the 850 going to 1,200. And here's where you see 0 going to, you know, the additional spaces. And then as we go down here, we just identified some of the items that contributed to the grossing factor being insufficient, you know, the elevators. And as you go down, you know, there's another elevator, and the stairs, and then additional circulation. So point being is, we're not saying that those items are totally missing. It's just that they were insufficiently sized. So obviously the AOC knew we needed stairs and an elevator. I'm not saying they missed that. I'm simply saying that that's how we illustrated the increase that we needed for the grossing factor. So all of that ended up, you can kind of see down here with the reconciliation. The original program as it came from the AOC was 20,550 square feet. And then what went in at phase A was a little over 23,000. And it stayed very close to that as we developed it on up into construction documents. So this number, the 23,000 and some change, is what the building actually ended up being. So it's a significant difference. And the reason this is important for us, well, there's really no option. We have to decide before we can even lay something out, because these buildings, as you all are, I'm sure, aware, are very complex as far as the circulation patterns. You know, you got the public, the private for the judicial staff, and then the prisoner circulation spaces, which cannot cross. And there's a lot of adjacency issues that have to be considered, even between departments that are along those paths. So it's not possible as you get into development to just, you know, add another room in or make it bigger. It can't happen. You kind of have to know on paper, first of all, you know, which spaces and how big they need to be before we can lay out a floor plan to show you in the first place. So that's the reason this is a discussion that, you know, before we you know, put pen to paper and actually show you something visually on a plan, it starts here, you know, with this document. So again, I didn't bring this up today to try to force you all to decide something today. It was more to help you understand the initial step in the process that we will need to take to verify exactly what's on this paper before we can show you something graphically. So I'll just kind of leave that idea with you, and you can kind of tell me if you want to think about it. I mean, I have actually sent this before, and I can resend it again for you to take a look at if you'd like. You're welcome to call me, and that's fine. I just want to make sure everyone, understands that'll be the first thing we need to nail. And then if we decide to make similar adjustments to Butler as we did in Crittenden, I mean, the precedent is, AOC approved it, but there is a process where they have to accept that. They have to, formally say, yeah, this is fine to make this adjustment. And then we have to have all that worked out before we actually start laying it out. So I'm just trying to get ahead of it so that as we get into the design, everyone understands this is, an important first step. So
I think from the family court judge perspective anyway, since I've not been involved to this point, and frankly, I don't have that ambition. I'm very trustworthy of the folks that are serving on this on the board to make a lot of these decisions. And as in most of these situations, anything we do is going to be an upgrade over what we do now. So, it's hard to even be too critical. I think as long as we can know where we need to go to get information about basically what the spaces would be if there aren't adjustments as it relates to those issues you mentioned, and then which I would assume we can coordinate, my staff can coordinate with Melissa or another board member to get some of the past documents that maybe you all have circulated among the board, just to kind of see what is the current plan without any adjustment.
Mm-hmm.
And then to understand, of course, I know about the child waiting area. I think you said there's a bathroom issue, and then a family court administrator space.
Mm-hmm.
And I have long-term stay. I'm short-term in the job at this point, 6 months, but my staff is all 16 years plus, and have worked in 4 different courthouses with 4 different types of facilities, including a new facility in Hancock County that frankly has more space than we need. And I know that's a different issue, but I just mean it's not all needed, on a day in and day out basis. Now, when we're there, it's utilized. But in any event, if we can just educate ourselves between now and some other time, and know how to get ourselves educated, and frankly, for me to coordinate with my staff about what spaces would assist us better, specifically in Butler County, I'm happy to give input on that. But beyond that, I don't know what else to say at this point.
Okay, well, I can go ahead and send you this file and the email it was attached to, which kind of gives some other explanation. I tried to do that a little bit verbally, but it'd be easier to digest it if you could just read it, So I'd be happy to send that on to you. And like I said, I wasn't looking for an absolute decision today. It's just that once we're turned loose, this will be the first thing we need to nail. So I'll go ahead and send that back out. I'll just copy everybody on it, and that way you all can consider it. So it's really it's the family court spaces and it's the courtroom size. Those are really the only 2 issues that you have to make a decision on. The items related to the grossing factor and all that, that's just an explanation to you. We just have to do what we have to do there. There's really no decision for the PDB on those items. It's really what you see on this one screen that you all would need to evaluate. I mean, honestly, if it would help you, I could probably send you, normally I wouldn't do this, but in this case, the buildings are so similar. I could send you how this worked out on Crittenden, so you can kind of look at a floor plan and understand, what the impact was and how that decision ended up there. So it might give you something to wrap your head around easier than just numbers on a page.
I think that would be
great.
and that would be helpful on the family court end, but also if there's something, and there may not be a drawing to this effect, but something that would say, but as we are now, here's what it would be, you know,
Yeah.
here's the added space. And if that doesn't exist, that's fine.
Yeah, that we don't have a drawing because we don't really do a drawing till we have a
Sure.
program. Right now, we don't have a drawing of it the way it is. But
is it safe to just say that once we identify on your drawing what the basically the family court administrator space, the child space and bathroom, just with or without those is basically the question, right?
For you, yes.
Yes. And I understand that's
Yep.
going to adjust other spaces, but okay.
Mhm.
Yeah. And that's
Yep.
no, that would be helpful. And,
Yep,
and
sure.
we can assess whether that's something, and I'm sure it's all, again, it's sort of like Hancock came in, the space is helpful. The question, I guess, in the end for the board is, and for AOC is whether whatever that additional cost and those adjustments are worth the additional use. And until I see the space, once we see it, we'll say, oh, we would use that every time, you know, or that would be once a month or once a quarter, you know, and that's really what we would want to see about it.
I got you. And the thing with the spectator area, a lot of that, I can tell you where that came from. Much of that additional spectator area was not due to day-to-day operations, but it was related to the times when you had jury selection.
Oh, sure.
So, you know, there are reasons for it. And again, the AOC ultimately said, sure, go ahead. And, you know, that's what we'll do. And then that's what we've got. It's ready to, you know, it got approved. It's going out to bid that way. So, you know, I'm not trying to talk you into it. Don't get me wrong. I'm not trying to say, well, they got it and therefore you ought to have it. But, you know, there was a significant process on this exact same program by someone else. And you might as well benefit from that discussion and not have to repeat. I guess I'm trying to do is streamline it so it doesn't take 6 months to figure that out like it did on Crittenden County. You know, I think we can probably get to the bottom of it a lot quicker here since we've been through the process before. So I'll go ahead and send you all this. I'll send you a copy of the Crittenden plans so you can see that, you know, what's on the plan relative to what's on this paper you're looking at right now. And that should help you to visualize it a whole lot better. And again, I'm not trying to tell you that even if you end up doing all of this, that every little last detail has to look just like Crittenden. I don't mean that. That said, as you all know, there are a lot of functional adjacency issues that lead the floor plan design to be what it is, because, you know, A needs to be next to B and so forth. Same thing, you know, we assumed initially, like with those site drawings that we gave you, we actually used the Crittenden County footprint in its enlarged state to put on there kind of as a worst case scenario, because we knew that if we showed it exactly as it was in the program and then it grew some, you know, you're going to have a few extra feet here or there that you got to deal with on the site. So just if it helps, you know, what we've shown you so far assumes the bigger building. So it's kind of a worst case scenario. It's not going to get any worse than that. So, all right.
Jeff, would it help for them to just look at Bath County to see one without? Or you want to? I'm just saying.
Let me look at that. Yeah,
go ahead.
I will look at that and see what. I mean, maybe we can talk. What I don't want to do is confuse them with too much.
Okay.
Bath County had its own set of adjustments which were different. You know, for example, they added a jury into the non-jury courtroom in Bath County. So there were other things that were done there, but it was it was of a very similar size, and it certainly doesn't hurt to look at it. But you do have to recognize that the Bath program, even though its size is very similar to this one, it does have more differences than the one in Crittenden did.
Okay.
So, but yeah, doesn't hurt to take a look at it. You might see something about it For example, and I'll tell you this right up front, that a big part of the discussion, the smaller the building gets, the more of a challenge it is to work it out. It's not as forgiving as a large building when it comes to laying out spaces. So with the 3 judges you have programmed into this building, the 3 judge offices, it is not possible for all 3 of those suites to be on the 2nd floor where the courtrooms are. It's just the way it balances out. You end up with this void on the 1st floor with nothing in it, which obviously, particularly nowadays, no one can afford that. And it makes the 2nd floor artificially large. So what we did, and you'll see this when you look at the plan, is one of the courtrooms or one of the judges' chambers is downstairs, but it's right adjacent to the judicial elevator. So as far as walking distance, it's really not, it's more of a mental thing that it's on the 2nd floor, but distance wise, it's really not far away. But that's what we had to do to balance the floors out to make the building as efficient as possible with the floor areas. So, that might be one of the first things you say is, well, we've got a judge downstairs and the courtrooms are upstairs. Yes, that's true. You have to do that just to make it balance out. But I think, again, once the judges in Crittenden looked at it, they realized, okay, yeah, it's not a big deal. You walk out of the courtroom, you pop down the elevator and you're right there. So it's little things like that when you look at the layout that you might have questions about. And, you're welcome when you see it, just give me a call and I can talk you through why you see something. If it looks odd to you, I can guarantee you there's a reason. But this, we don't expect to work all this out, with materials I send you and with phone calls. Once we're, really into it and we've got the program worked out, I'll come down there and sit down with the judges and the clerk and we'll sit around the table and figure this stuff out in person. But it will help you to have a little bit of it, to wrap your head around before we sit down and do that.
All right. Well,
Okay.
thank you, Jeff.
Yeah, you're very welcome.
Jeff, quick question, just
Yeah.
from a practical standpoint, on the difference in spectators in the jury room, what was the capacity after?
I've got an email that spells all that out.
Okay.
So let me dig that up and I'll send it to you so you can see what the impact was.
That'd be great.
And I've got all those figures. I can't rattle them off to you, but yeah, I've got that, and I think it'll be helpful for you to see it on paper so you can understand what we did and what the net effect was. Because what we did, again, we did not change the litigation area at all. It was just a matter of adding more rows of seats. And the other thing, and this is kind of for everybody, this always comes up, and the email explains this, but I think it might be good if I explain it here, is that the number of spectators, we always show 2 numbers. One is the building code requires you to use a certain dimension per person for those spectator seats, and it's 18 inches. That's the number you have to use and put on the drawings, and that's the calculation for exiting and all of that. That's what it comes from. That said, we know that not everybody's 18 inches. And so we also put another number on there, figuring the number at 24, which is a little more comfortable. So you'll have the 2 numbers. In other words, the 24 inches, probably the number you would use to say how many people can we reasonably get in there. But the 18 is what the code says you can squeeze in there if you want to. So I think that's why it's probably good for you to look at the email. It explains all of that. But when you see the 2 numbers, that's the explanation for it. One is the legal requirement and one is more of a practical consideration. Okay.
Okay, is there anything else to bring before the board this morning? If not, we need to set a date for our next meeting. If Tuesday mornings will still work for everyone, we're looking at Tuesday, June the 20th. Will that work for everyone?
That's fine. That's fine by me, Judge.
That works for me as well.
Judge Coleman?
Yeah, I'm good.
That was the 20th, Judge Fleener,
Yes.
on Tuesday, 9 o'clock, or 8 o'clock girls' time.
Yes. Yes, sir.
Okay.
Okay, if there's nothing else, then we will see you all again on June the 20th at 8 a.m. With that, I need a motion to adjourn.
So moved.
Motion and a second. All in favor can sign off. Everyone have a good day.
Yeah.
All right. Thanks,
Thank
everybody.
you.